Hi, Mod. Do we have sound? It's doing that freaking light thing where it's going light and dark too. What the hell is going on with this shit? Weird. Weird, weird, weird. Mod, do we have sound? Mod. Maybe we don't have sound. Oh, okay, good. What do you know? Well, this case isn't nearly as interesting as the last one. I'm sorry y'all missed the last one. It was a Wyoming case where this dude. I'll go back and read the first part again because it's pretty fucking hilarious. We're not gonna read the whole thing 'cause it's like 12 pages long, but like, uh, poor Wyoming got this case. Okay. All right. So in the appeal now before the court, this is the Wyoming case, Duke versus Housen. The appellant defendant challenges the jury verdict and district court judgment entered against him awarding the appellee plaintiff based upon defendant's allegedly grossly negligent infection of the plaintiff with venereal disease, compensatory and punitive damages in the sum of $1,300,000. For the reasons stated in detail herein, we shall reverse on the ground that the action is barred by the statute of limitations. Facts. In early April 1970, plaintiff was living, working, and going to college part-time in Washington, D.C. area. On April 4th of that year, she was introduced by her brother to the defendant, and on that same night and the early morning of April 5th, following dinner and dancing plus moderate drinking, engaged in sexual intercourse with the defendant in the front seat of his pickup truck. On April 8th, at least partially in response to defendant's sudden and convincing professions of love and desire to marry, plaintiff met defendant at LaGuardia Airport in New York and subsequently traveled by truck with him from New York to Denver, Colorado, engaging on and off in acts of sexual intercourse with the defendant along the way. Upon reaching Denver, defendant, having lost interest in plaintiff, lodged her in a local hotel and left for his home in Meeteetse, Wyoming. Plaintiff, after contacting her brother and waiting for him to arrive, subsequently traveled to Meeteetse and confronted defendant concerning his behavior. As a result, it was agreed that defendant would accompany plaintiff and her brother back to Washington, D.C. and apologize to her family. Yet, after arriving in Washington and discussing the situation with her family, plaintiff, for some reason which is neither totally clear nor probably capable of elucidation, accompanied the defendant to New York, there occupying a hotel room together and engaging once more in sexual intercourse. Finally, the next morning of April 24th, 1970, defendant broke off his relationship with the plaintiff and informed her for the first time that he had the venereal disease gonorrhea, and now she probably had it too. At the trial, for the presentation of voluminous testimony by both parties, it was established that at some point prior to March 22nd, 1970, defendant had become aware that he was probably infected with venereal disease, for on that day he visited a doctor in Dallas, Texas, complaining of pain and a urethral discharge. In response, examining physician took a sample of the discharge for testing and administered a large dose of fast-acting penicillin, telling the defendant to return the next day for the test results. When the defendant returned on March 23rd, the test results for gonorrhea having been found positive, a larger dose of longer-acting penicillin was administered, and the defendant was advised to see his own doctor for further treatment. The defendant then left by plane for New York, arriving the same day, March 23rd, where he immediately upon arrival contacted his own physician who, after an external examination, stated that he can find no clinical evidence of any gonorrhea. The defendant had no current urethral discharge. On the basis of the previous treatment and this current information, the defendant asserted at trial that it was his belief that as of his first sexual contact with the plaintiff on the night of April 4th and 5th, 1970, his infection with gonorrhea had been cured. Plaintiff, after being told by defendant on April 21st that she probably had contracted gonorrhea from him, she should see a doctor, left New York for Washington, D.C., and the following day, April 22nd, visited her personal physician, who, through a smear test, confirmed that gonorrhea was present. In response to medication, plaintiff's infection with her physician, described as a classic case of asymptomatic gonorrhea, was arrested by May 14th. But more serious problems were to develop. Beginning January 1973, plaintiff noticed a pain in her lower right side, which by March of 73 had become so severe and constant as to require medical attention. After various external medical tests provided negative results and antibiotic medication proved ineffective, major exploratory surgery was performed in July. As a result, plaintiff's physician found that because of the gonorrhea infection and possibly other related secondary infections as well, scar tissue adhesions had formed within a number of areas of the appellee's lower abdomen. He testified that although he had cut loose and detached the adhesions, that somewhat relieving the temporary and severe pain, because of the nature of the scar tissue involved, new adhesions would eventually form, and the pain would probably return again and continue in a cyclical manner for the remainder of the plaintiff's life. He further advised that because of the scarring involved, plaintiff's ability to bear children would probably be greatly reduced. So that's the lawsuit. She files for a bunch of damages. That's what I was reading for the last half an hour. Nobody can hear me. The result is that she waited like 3 years and 361 days to file the lawsuit. So the statute of limitations barred her from actually being able to bring the suit, and the jury verdict was reversed. This one's not so funny. Laboratory Corp of America versus Hood, Maryland Supreme Court case, 2006. Parents brought suit against Laboratory Corporation, alleging that its erroneous report stating that their fetus did not have cystic fibrosis, a genetic disease that is likely to be fatal, contributed to the decision to have the child. The United States District Court for the District of Maryland certified the questions to the Court of Appeals. We have before us 3 questions of law certified by the United States District Court of the District of Maryland pursuant to the Maryland Uniform Certification of Questions of Law Act, Maryland Code subsection 12-601 through 12-613 of the Judicial Procedure Article of Maryland. The questions arise from an action by Karen and Scott Hood, Maryland residents, against 2 North Carolina corporations, Laboratory Corporation of America and Laboratory Corporation of America Holdings, which we shall refer to collectively as LabCorp. This action is one that is often but is misleadingly denominated as wrongful birth. The Hoods complain that the defendants were negligent in misreading a chromatograph of the DNA from an amniotic fluid specimen extracted from Mrs. Hood and erroneously reported that the fetus was not likely to be affected by cystic fibrosis. Relying on the erroneous report, Mrs. Hood elected to continue with the pregnancy, and that resulted in the birth of their son Luke, who does have cystic fibrosis. The Hoods now seek to recover damages for the cost of raising and caring for Luke. The questions certified to us are: 1. In a case where a medical laboratory receives a specimen from a Maryland physician and erroneously interprets a specimen in another state, causing injury in Maryland to Maryland residents, should this court follow the standard of care exception in the restatement first of the conflicts of law and apply the substantive law of the state where the erroneous interpretation took place? 2. Does denying Maryland residents the right to bring a wrongful birth action by applying North Carolina law violate the public policy of the state of Maryland? The problem underlying the first 2 certified questions is that while Maryland recognizes an action of this kind by the parents, North Carolina apparently does not, and the district court, which must apply Maryland law, including the Maryland law on conflicts of laws, desires to know whether in the situation at hand, if the action were filed in a Maryland court, we could apply the substantive law of Maryland where the injury occurred, or that of North Carolina where the negligent acts and omissions took place. The Hoods are Maryland residents. Their first child, Zachary, was born in 1997 and diagnosed with cystic fibrosis when he was 2. In the present state of medical science, persons with cystic fibrosis are doomed to suffer from lung, gastrointestinal, pancreatic, heart, and other organ diseases and rarely live beyond their mid-30s. In order to develop cystic fibrosis, a child must receive a particular gene mutation from both parents. After Zachary was diagnosed, the Hoods learned that they both carry the recessive delta F508 gene mutation that causes one of the most severe forms of cystic fibrosis. Because they're both carriers of that mutation, each of Karen's pregnancies carries a 25% chance of having a child with cystic fibrosis. In 1999, Mrs. Hood became pregnant again, and she and her husband were referred by Mrs. Hood's obstetrician to a genetic counselor. Genetic testing performed on the fetus revealed that it had cystic fibrosis, whereupon Mrs. Hood terminated the pregnancy. In August 2001, she became pregnant a 3rd time and again decided to have the fetus tested. The Hoods had already made the decision to terminate the pregnancy if the fetus tested positive for cystic fibrosis. On November 22, 2001, Mrs. Hood had amniocentesis performed in Maryland by her obstetrician, Thomas Pinkert. LabCorp operates a nationwide network of 35 primary testing locations and more than 101,000 patient service centers, 8 of which are located in Maryland. Although it receives specimens from physicians and from its various patient service centers throughout the country, LabCorp performs all of its genetic testing and amniotic fluid at its Center for Molecular Biology and Pathology in North Carolina. The company markets genetic testing services to couples, such as the Hoods. Before the specimen taken from Mrs. Hood was sent to LabCorp for testing, the Hood's genetic counselor, Amy Kimball, who worked in Dr. Pinkert's office in Maryland, informed LabCorp that both Karen and Scott Hood carried the CF gene. The sample was sent to the LabCorp facility in North Carolina, where the DNA in it was subjected to a chromatograph that was analyzed by 2 LabCorp employees, Marcia Eisenberg and Nicholas Brown. In conformance with the analysis done by Eisenberg and Brown, LabCorp reported to Dr. Pinkert that although both parents were carriers of the Delta F508 mutation, the amniotic fluid was negative for 31 common CF genetic mutations, and the fetus is not expected to be a carrier of cystic fibrosis nor be affected by cystic fibrosis. Pinkert sent the report to the Hoods. Based on the LabCorp report, the Hoods elected to continue the pregnancy, resulting in the birth of Luke on May 3, 2002. 3 months later, the child was found to be positive for cystic fibrosis. In September 2002, LabCorp issued a corrected report which noted that the original chromatograph did indeed demonstrate the fetus was positive for the Delta 508 mutation that causes cystic fibrosis. The box containing the word Del F508 was marked with an asterisk indicating that the fetus had CF and stated that Eisenberg and Brown had misread the chromatograph. The district court issued a partial ruling on the cross motions for summary judgment. In that ruling, the court held that under Maryland law, the Hood's action for negligence, not breach of contract, and that the Maryland law of negligence therefore applied. The court observed that in diversity cases such as the one at hand, it was obliged to apply Maryland's choice of law rules in determining that Maryland adheres to lex loci delicti principles for all tort claims, i.e., we apply the law of the place where the tort or wrong was committed. It concluded that under application of these principles, the place where the last event required to give rise to the tort occurred determines the law that should apply. That personal injury claims the last event required to give rise to the tort is the injury, and the injury is the action occurred in Maryland where Luke was born. Whether Maryland or North Carolina law applies is critical to the Hood's case. In Alonzo versus Dingfelder, 315 North Carolina 1985 case, the North Carolina Supreme Court held that the parents of a child born with severe birth defects did not suffer any legally cognizable injury, and thus the Hood action could not succeed under North Carolina law. In Reed versus Compagliano, Maryland court case 93, responding to a certified question from the U.S. District Court, we adopted a completely opposite point of view, knowing that the Alonzo's analysis does not recognize even the economic impact on the parents, and in that respect is contrary to Maryland law. The divergence forms the basis of the second certified question. If the application of restatement section 380 subsection 2 would ordinarily cause North Carolina law to be applicable in this case, but Maryland nonetheless refused to apply that law on the ground it would be contrary to Maryland public policy to deny a Maryland resident suing in Maryland a court for wrong committed in Maryland a remedy recognized in that state. Maryland public policy. We have not previously applied a public policy exemption to the lex loci delicti doctrine. That means where the wrong was done, the law of where the wrong was done. Although our case strongly indicates that we would do so in a proper case. We have long recognized and have on occasion applied such an exception under analogous lex loci principles and have implicitly recognized the exception in a tort action subject to lex loci delicti. In a breach of contract actions, this court traditionally applies the doctrine of lex loci contractus, under which, in deciding upon the validity of the construction of a contract, we generally apply the law of the place where the contract was made. We have just as consistently held, however, that lex loci contractus principle is not inflexible and it does not apply to a contract provision which is made against Maryland public policy. Bethlehem Steel Company versus G.C. Zarnes and Company, 304 Maryland Supreme Court, 1985, and cases cited therein. We were cautioned in Bethlehem Steel that merely because Maryland law is dissimilar to the law of another jurisdiction does not render the latter contrary to Maryland's public policy, and that for another state's law to be unforeseeable, there must be a strong public policy against its enforcement in Maryland. Quoting in part from Texaco versus Van Dien Bolsch, 242nd Maryland Supreme Court 1966 decision, and also National Glass versus J.C. Penney, a 1994 Supreme Court decision. In Hutz versus Boyer, 1969 Maryland Supreme Court decision, and Houch versus Connor, a 1983 Supreme Court decision in Maryland, we applied a public policy exception in the context of workers' compensation statutes, which we recognize had some affinity to contract or tort principles, but were sufficiently different from both to be considered separately. The issue in those cases was whether Maryland would allow a fellow employee's action, an action implicitly permitted under Maryland workers' compensation law, but not permitted under the law where the parties were employed, Hutzel, or where an action occurred, Hotch. In Hutzel, although the parties were temporarily employed in Virginia, the employment-related accident occurred in Maryland, and the parties were both residents of Maryland. In rejecting the application of the Virginia law, which otherwise would have been required, the court observed that Maryland has a genuine interest in the welfare of a person injured within its borders who may conceivably become a public charge due to disabling injury, and that the social and economic problems following in the wake of a serious injury, as they may affect the dependents of the person injured, are properly matters of public concern. That's from Hutzel case. The Hotch court regarded that as public policy exception and applied that exception to a situation in which the co-employees were residents of and employed in Maryland, but where the accident occurred in Delaware. In Hartford Mutual versus Brauchi, Maryland 1968 Supreme Court decision, a Maryland couple sued a Maryland company in Maryland court for damages arising from an automobile accident that occurred in Virginia. In addition to any direct personal injuries, the husband sued for loss of consortium, an action that, by statute, was not allowed in Virginia. We concluded that under lex loci delecti principles, Virginia law would generally apply, but acknowledged the question of whether there is extent in Maryland such a strong public policy in favor of recovery by a husband for loss of consortium as to require its courts to refuse to apply the law of a sister state which does not recognize such a right. We concluded that there was, quote, no such strong public policy. We observed that the husband's right to recover for loss of consortium had been characterized as an anachronism, a fossil from an earlier era, an anachronistic common law rule, and a vestigial right, from which we said, hardly indicates the recognition of a strong public policy in Maryland in favor of recovery for deprivation of consortium. Although we did not find in Hartford Mutual a sufficiently clear and strong public policy to disregard the lex loci delecti in favor of allowing a loss of consortium claim, the case cannot be read other than as recognizing that there is a public policy exception to the lex loci delecti rule and that we would apply it when an appropriate case arose. See also Linton versus Linton, 1980 case. Ree versus Combined Enterprises, another 1988 case. Black versus Leatherwood, a 1992 case. We can find no principal basis upon which to recognize such an exception in contract and workers' compensation cases, but to deny it in tort cases. The question certified is thus presented. Does denying Maryland residents the right to bring a wrongful birth action by applying North Carolina law violate the public policy of the state of Maryland? Should the district court, in light of our response to the first certified question, still find that this question relevant? Our answer is yes. This is not a case like Hartford Mutual, which needs to be examined in context. Under long-established Maryland common law, only a husband could sue for loss of consortium in Maryland, and the loss of society, affection, assistance, and conjugal fellowship with his wife. The wife had no comparable right. See Coastal Tank Lines versus Canoles, a 1955 case. That anomaly was founded on the ancient common law premise that the husband was entitled to his wife's services and was obliged to support her, but the wife was not entitled to her husband's services and was not obliged to support him. As the clearest basis for maintaining that unequal right in the middle of the 20th century, the Coastal Tank Lines Court quoted the pronouncement from the House of Lords decision in Best versus Samuel Fox Company Limited, 1952 British case, affirming the common law is a historical development rather than a logical whole, and the fact that a particular doctrine does not logically accord with another or others is no ground for its rejection. In Deems versus Western Maryland Railroad, a 1967 case, decided on a mere 7 months before Hartford Mutual, the court, in considering a constitutional equal protection challenge to such an unfair rule, decided in lieu of either abolishing the action or extending it to the wife to regard it prospectively as a joint action for injury to the marital relationship. Although preserving the action in its converted form, there is nothing in the Deems opinion to suggest that the court had any great attachment to the action. Rather, it transformed the action into a joint one only to avoid having to resolve the federal constitutional attack on it. And indeed, the court expressly cautioned that it was not deciding the effect that any federal statute might have in foreclosing on the claim for consortium under Maryland law. As noted in the Hartford Mutual case, still considered the action, even in its new emanation, as vestigial, anachronistic, and a fossil from an earlier era, and consistently with the caution expressed in Deems, did not regard the existence of the action in Maryland as a reason not to apply Virginia law. The right of parents to bring an action for wrongful birth is quite different. It is not a vestige of ancient common law illogic, but, as we noted in Kasama versus Maggot, 2002, it is a type that, as a practical matter, could not have been brought before the last half of the 20th century. At its core, We set it rests to a large extent on the more recent advances in medical and scientific knowledge that made contraception more practical and reliable and made potential fetal injuries and defects detectable prior to birth and even prior to conception, coupled with the loosening of the loosening of the fetters of abortions triggered by Roe v. Wade. In Reed versus Capagnola, we pointed out that the clear majority of courts that has considered the type of medical malpractice case alleged by the Reeds has concluded there is legally cognizable injury proximately caused by the breach of duty. There is at least some economic harm to the parties in these cases, a harm that can be quantified under general rules relating to tort damages. We expressly rejected the approach of Zoliano as contrary to both Maryland law and the law of most states, and adopted instead the view of the Massachusetts court in Vicario v. Musinki 1990 case that the harm is not the birth itself, but the effect of the defendant's negligence on the parents resulting from the denial to the parents of their right, as the case may be, to decide whether to bear a child or whether to bear a child with a genetic or other defect. Reed was a carefully considered and deliberated recognition that when prospective parents relying on the negligent act or omission of a healthcare professional elect to continue a pregnancy that they otherwise would have lawfully terminated, and as a result are burdened with the cost of the expense of raising a child with a serious genetic or other physical or mental defect, they have been injured and have the right to seek damages from that injury from the person whose negligence led to the injury. That right is a matter of important public policy in this state, flowing not from this court's considered view, but as well from the statute. See Maryland Code 20-209B of the Health General article, precluding the state from interfering with the decision of a woman to terminate her pregnancy at any time during the pregnancy if the fetus is affected by a genetic defect or serious deformation or abnormality. We thus conclude that if application of North Carolina law would preclude this cause of action on the grounds stated in Laziano that no injury has occurred, we would hold the aspect of North Carolina law to be contrary to the clear, strong, and important Maryland public policy, and we would not apply it. The court commented on the difficulty of determining whether Laboratory Corporation has a duty to Scott Hood, the father of Luke Hood. Certified questions of law answered are set forth above, cost to be equally divided by the parties. Well, that's that case. I think that concludes our stream for tonight, folks. We got some sound at least. Well, bye out there in YouTube land. Y'all have a good night. God bless you. Stay safe. Tip your waitresses. Tip your bartender. Have a good one.